Another victory for nonviolent felons was just handed down this week by a federal judge in Pennsylvania. Let's talk about it. Hello everyone, I'm attorney James Phillips, and thanks for tuning in to the Firearm Firm channel. Since the United States Supreme Court decision in New York State Rifle and Pistol Association versus Bruin, courts have been striking down certain restrictions on individuals' right to bear arms. The most recent example of this comes out of the United States District Court for the Eastern District of Pennsylvania in the case of Williams v. Garland. In this case, the plaintiff, Edward Williams, challenged his lifetime ban on possessing a firearm pursuant to 18 U.S.C. 922, subsection G1. Section 922 G1 makes it unlawful for anyone who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. Mr. Williams received this ban as a result of his second DUI, which, although is considered a misdemeanor in Pennsylvania, carries up to 5 years in prison. Mr. Williams did not serve any time in prison, but he did serve some time under house arrest. This case began back in 2017 when he decided to file a federal lawsuit, but in that case, the court granted a summary judgment in favor of the defendants after finding the 922 G1 had survived intermediate scrutiny as applied to the plaintiff, and the Third Circuit Court of Appeals affirmed the lower court's decision. Now, some time went by and then the Bruin decision came out, and in 2022, Williams filed a petition for rehearing en banc, and the Third Circuit Court of Appeals vacated the prior judgment and remanded the case back to the district court for reconsideration in light of the Bruin decision. While the case was back before the district court on remand, the Third Circuit Court of Appeals decided the Range case, which we've done 2 videos on, and I will put a link to both of those videos discussing the Range decision down in the description section for anyone that's not familiar with the case. Ultimately, the district court, applying the standard adopted in Bruin, determined that prohibiting Williams' possession of a firearm due to his DUI conviction is a violation of his Second Amendment rights, as it is inconsistent with the United States tradition of firearms regulations. In coming to its determination, the district court relied on the narrow ruling in the Range decision. Remember, in the Range case, the court's ruling did not apply to all nonviolent felons, but it only applied to Mr. Range himself based on Mr. Range's criminal history. However, this court found that the narrow analysis in the Range case applied to Mr. Williams. And in this case, the court found, like in Range, that the Second Amendment does not only belong to law-abiding citizens, but presumptively belongs to all people who may then be subject to the stripping of associated rights. Therefore, Second Amendment protections applied to Mr. Williams and his proposed conduct. After determining that the Second Amendment does in fact apply to Mr. Williams, the burden then shifted to the government to show that Section 922 G1 was in fact consistent with the nation's history of firearm regulations as applied to Mr. Williams' facts. Fortunately for Mr. Williams, the government was not successful, and the court wrote, "The court finds that the government has not carried its burden in proving that the United States tradition of firearm regulation supports stripping an individual of their right to possess a firearm because they had previously driven while intoxicated. The application of Section 922 G1 to plaintiff therefore constitutes a violation of his Second Amendment rights, and the court finds that the plaintiff is entitled to the requested relief." As of the filming of this video, the government has not filed a notice to appeal, but I do expect one will be coming sooner or later. So, does this mean that any nonviolent felon or anyone convicted of a nonviolent misdemeanor that is punishable by more than 1 year in prison can possess a firearm legally under federal law? No. Just like in the Range case, this ruling is only applicable to Mr. Williams himself based on Mr. Williams' history. However, this is a victory for all those affected by 18 U.S.C. 922 G1, and I do believe a case that will apply to everyone is coming our way. In fact, the United States Supreme Court has decided to hear the Rahimi case this term. The issue in the Rahimi case is whether or not the prohibition found in 18 U.S.C. 922 G8 violates Mr. Rahimi's Second Amendment rights. 18 U.S.C. 922 G8 prohibits individuals who are subject to a court order restraining them from harassing, stalking, or threatening an intimate partner of such person or a child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child. The outcome in the Rahimi is definitely going to be a major factor in the fight for nonviolent felons to lawfully possess a firearm. Be sure to let us know what you think about this 2A victory down in the comments section, along with any questions you may have about this video. Also, Don't forget to show your support for the Second Amendment by hitting the like button, and if you have not already done so, be sure to subscribe to the Firearm Firm channel. Until next time, stay armed and educated.